the American people start to pay attention after the Library of Congress proves President Obama not to be a United States citizen. When are people going to wake up and actually look at the facts? The truth about the 14th Amendment has been out there for so long, but no one seems to care what the framers said, and the facts are 100% ignored. We do not need the courts to figure out what natural-born citizen means, nor do we need Congress to do an investigation, because the truth is already available. All they need to do is look at the facts. For the record, the 13th Amendment to abolish slavery was adopted on December 6, 1865. The Civil Rights Act of 1866, which granted those former slaves citizenship, was enacted on April 9, 1866. And the 14th Amendment, which made the Civil Rights Act constitutional, was proposed on June 13, 1866, and after much debate, was adopted on July 9, 1868. So they were all dealt with during the same time frame, with the same congressmen involved in each bill. The 14th Amendment represented the overruling of the Dred Scott decision, ruling that black people were not and could not become citizens of the United States or enjoy any of the privileges and immunities of citizenship. The Civil Rights Act of 1866 had already granted U.S. citizenship to all persons born in the United States, as long as those persons were not subject to a foreign power. The framers of the 14th Amendment added this principle into the Constitution to prevent the Supreme Court from ruling the Civil Rights Act of 1866 to be unconstitutional for lack of congressional authority to enact such a law, and to prevent a future Congress from altering it by a mere majority vote. Which means the Civil Rights Act of 1866 still stands because the 14th Amendment was never repealed. The left/progressives have totally perverted the 14th Amendment with their birthright citizenship lie. To truly understand the 14th Amendment and what the framers' original intent was when writing it, you must go back to the framers' writings and the congressional debates. Obviously, the logical people to research would be Senator Lyman Trumbull, author of the Civil Rights Act of 1866, co-author of the 14th Amendment's Citizenship Clause, co-author of the 13th Amendment to abolish slavery, Illinois Supreme Court Justice from 1848 to 1853. Senator Jacob Howard worked with Lincoln to draft the 13th Amendment, served on the Joint Committee on Reconstruction, which drafted the 14th Amendment to the United States Constitution, co-author of the 14th Amendment's Citizenship Clause. Honorable John Bingham, principal framer of the 14th Amendment, judge advocate in the Lincoln assassination trial, prosecutor on impeachment of Andrew Johnson. So let's get to the facts. I suppose the easiest way to lay this out would be to go in chronological order, starting with Representative John Bingham, 1862. Congressional Globe, 37th Congress, 2nd Session, page 1639.
All from other lands, who by the terms of congressional laws, and a compliance with their provisions, become naturalized, are adopted citizens of the United States. All other persons born within the Republic, of parents owing allegiance to no other sovereignty, are natural-born citizens. Gentlemen can find no exception to this statement touching natural-born citizens, except what it says in the Constitution relating to Indians.
The next would be the Civil Rights Act of 1866. The original bill was introduced on January 5, 1866, and read, "Be it enacted by the Senate and House of Representatives of the United States of America, in Congress assembled, that there shall be no discrimination in civil rights or immunities among the inhabitants of any state or territory. After a week and much debate from the Judiciary Committee, it was sent to the floor with an amendment by Trumbull, as you can see here. The amendment reads: in Section 1, Line 3, after the word "that," insert that all persons born in the United States and not subject to any foreign power, excluding Indians not taxed, are hereby declared to be citizens of the United States without distinction of color. And as you can see, the bill was then passed in the affirmative. You can now see the difference between the original and the final bills. The bill then went over to the House of Representatives, where it passed, along with Howard and Trumbull's amendment. John Bingham speaks on the amendment to the bill.
I find no fault with the introductory clause, S-61 bill, which is simply declaratory of what is written in the Constitution, that every human being born within the jurisdiction of the United States, of parents not owing allegiance to any foreign sovereignty, is, in the language of your Constitution itself, a natural-born citizen.
The bill was then sent to President Andrew Johnson, and Johnson vetoed it. It was then sent back to Congress, where both houses passed the bill, overriding the president's veto. Next, we'll move on to the 14th Amendment. If you look at the congressional debates, while they were debating the 14th Amendment, you will find the truth, and you will see that the 14th Amendment has been 100% perverted. When the bill came over from the House of Representatives, this is what it looked like. You can see that the phrase containing jurisdiction had not yet been added. During the debates, many argued against the bill, including Senator Milton S. Latham. This man got it right.
Mr. Speaker, we seem to have fallen upon an age of theories. We are told, from day to day, with much seeming sincerity, and an air of the most profound political sagacity, that the Union, when restored, must be restored upon a basis which will make it as permanent as the everlasting hills, and as invulnerable as the throne of the Eternal, and with such safeguards that even treason will no longer be possible within its jurisdiction.
Then, you have Senator Edgar Cowan. This speech he gives is incredible and tells why the Citizenship Clause amendment was needed. And it certainly wasn't for the left to use to make anyone born here a citizen.
The honorable senator from Michigan has given this subject, I have no doubt, a good deal of his attention, and I am really desirous to have a legal definition of citizenship of the United States. What does it mean? What is its length and breadth? I would be glad if the honorable senator, in good earnest, would favor us with some such definition. Is the child of the Chinese immigrant in California a citizen? Is the child of a gypsy, born in Pennsylvania, a citizen? If so, what rights have they? Have they any more rights than a sojourner in the United States? If a traveler comes here, from Ethiopia, from Australia, or from Great Britain, he is entitled, to a certain extent, to the protection of the laws. You cannot murder him with impunity. It is murder to kill him, the same as it is to kill another man. You cannot commit an assault and battery on him, I apprehend. He has a right to the protection of the laws. But he is not a citizen, in the ordinary acceptation of the word. It is perfectly clear that the mere fact that a man is born in the country has not heretofore entitled him to the right to exercise political power. He is not entitled, by virtue of that, to be an elector.
And he goes on to say, which is mind-blowing.
I have supposed, further, that it was essential to the existence of society itself, and particularly essential to the existence of a free state, that it should have the power, not only of declaring who should exercise political power within its boundaries, but that if it were overrun by another, and a different race, it would have the right to absolutely expel them. I do not know that there is any danger to many of the states in this union. But is it proposed that the people of California are to remain quiescent while they are overrun by a floor of immigration of the mongrel race? Are they to be immigrated out of house and home by Chinese? I should think not. It is not supposed that the people of California, in a broad and general sense, have any higher rights than the people of China. But they are in possession of the country of California, and if another people, of a different race, of different religion, of different manners, of different traditions, different tastes, and sympathies, are to come there, and have the free right to locate there and settle among them, and if they have an opportunity of pouring in such an immigration as in a short time will double or treble the population of California, I ask, are the people of California powerless to protect themselves? I do not know that the contingency will ever happen, but it may be well to consider it while we are on this point. As I understand the rights of the states under the Constitution at present, California has the right, if she deems it proper, to forbid the entrance into her territory of any person she chooses who is not a citizen of someone of the United States. I think the honorable senator from Michigan would not admit the right that the Indians of his neighborhood would have to come in upon Michigan and settle in the midst of that society and obtain the political power of the state, and wield it perhaps to his exclusion. I do not know that anybody would agree to that.
Now, who, again, says the framers of the 14th Amendment had no clue or inclination of the issue on illegal immigration and anchor babies? Howard and Trumbull argued for including the phrase, and subject to the jurisdiction thereof. Senator Howard is on record to answer the question of how the term jurisdiction was to be interpreted and applied. He first claimed the amendment as being declaratory of current law, meaning it is not a new law. The current law that Senator Howard was referring to was the Civil Rights Act, while introducing Bill H.R. 127, the 14th Amendment. Jacob M. Howard, author of the Citizenship Clause, states,
"This amendment, which I have offered, is simply declaratory of what I regard as the law of the land already, that every person, born within the limits of the United States, and subject to the jurisdiction thereof, is by virtue of natural law, a national law, a citizen of the United States."
What exactly did "subject to the jurisdiction thereof" mean to the framers of the 14th Amendment? Luckily, we have Senator Lyman Trumbull, chairman of the Judiciary Committee, author of the 13th Amendment, and the one who inserted the phrase,
"The provision is, that all persons born in the United States, and subject to the jurisdiction thereof, are citizens." That means, subject to the complete jurisdiction thereof. Now does the senator from Wisconsin pretend to say that the Navajo Indians are subject to the complete jurisdiction of the United States? What do we mean by subject to the jurisdiction of the United States? Not owing allegiance to anybody else. That is what it means.
Senator Jacob Howard concurs with Trumbull's construction.
I concur entirely with the honorable senator from Illinois, Trumbull, in holding that the word jurisdiction, as here employed, ought to be construed so as to imply a full and complete jurisdiction on the part of the United States, whether exercised by Congress, by the executive, or by the judicial department. That is to say, the same jurisdiction, in extent and quality, as applies to every citizen of the United States now.
The Supreme Court case, Minor versus Happersett, states, "The Constitution does not, in words, say who shall be natural-born citizens. Resort must be had elsewhere to ascertain that. At common law, with the nomenclature of which the framers of the Constitution were familiar, it was never doubted that all children born in a country of parents who were its citizens became themselves, upon their birth, citizens also. These were natives, or natural-born citizens, as distinguished from aliens or foreigners. Some authorities go further and include as citizens children born within the jurisdiction without reference to the citizenship of their parents. As to this class, there have been doubts, but never as to the first. Supreme Court Case Res Publica vs. De Longchamps. Chief Justice Kean. This is a case of the first impression in the United States. It must be determined on the principles of the laws of nations, which form a part of the municipal law of Pennsylvania. And, if the offenses charged in the indictment have been committed, there can be no doubt that those laws have been violated. He goes on to say, the first crime in the indictment is an infraction of the law of nations. This law, in its full extent, is part of the law of the state, and is to be collected from the practice of different nations and the authority of writers. If you search the page, you will see that law of nations is mentioned about a dozen times. The OBOTs claim that whenever the founders/framers mentioned the words law of nations, that they were not talking about Vattel. Then why, I ask, when you search the page for Vattel, it's listed many times, and no other writers on the law of nations are listed? Why is that? In the 1814 Supreme Court case, the Venus, Chief Justice Marshall cites Vattel, saying, Vattel, who though not very full to this point, is more explicit and more satisfactory on it than any other whose work had fallen into my hands, says, the citizens are the members of the civil society, bound to this society by certain duties and subject to its authority. They equally participate in its advantages. The natives, or natural-born citizens, are those born in the country of parents who are citizens. As the society cannot exist and perpetuate itself otherwise than by the children of the citizens, those children naturally follow the condition of their fathers and succeed to all their rights. One last question. Why would you suppose that the OBOTs always use Supreme Court case Wonky-Mark? I'll tell you why, because they are pulled towards corruption. This is actually the case where the law went astray. Now why would that be? Because Justice Horace Gray, who gave the opinion in Wonky-Mark, was appointed by none other than the original usurper, Chester Arthur. As you can see, Chester Arthur was born in 1829 in Fairfield, Vermont. But, looking at his father's naturalization papers, he didn't become a citizen until 1843. Meaning, Chester was not born to two citizen parents. So, the people back then that accused Chester Arthur of not being a natural-born citizen were right all along. If this isn't proof what a usurper can do to a country, I don't know what is. It seems Justice Horace Gray knew the law in 1884, but by the time Wonky-Mark came along, 15 years later, he had forgot it. Quoting Justice Gray from the Supreme Court case, Elk v. Wilkins. The main object of the opening sentence of the 14th Amendment was to settle the question, upon which there had been a difference of opinion throughout the country and in this court, as to the citizenship of free Negroes, and to put it beyond doubt that all persons, white or black, and whether formerly slaves or not, born or naturalized in the United States, and owing no allegiance to any alien power, should be citizens of the United States and of the state in which they reside. The first line of the Naturalization Oath of Allegiance to the United States of America states, I hereby declare, on oath, that I absolutely and entirely renounce and abjure all allegiance and fidelity to any foreign prince, potentate, state or sovereignty, of whom or which I have heretofore been a subject or citizen. Immigrants becoming citizens must take an oath of sole allegiance to the United States. Now why would that not be expected also of citizens born here? If you are born to two citizen parents, your allegiance is passed down. If you are not born to two citizen parents, you must take the oath. Simple as that. Vattel facts. Vattel's authority, as an institutional writer, extended to the United States, where he was cited in court cases between 1789 and 1820, no less than 92 times, on matters pertaining to the law of nations. We're coming after you, Obama. And we will not stop until you are removed and prosecuted to the fullest extent of the law. And to Congress and the mainstream media. You will be held accountable for aiding and abetting a criminal and for ignoring the American people. We have been telling you for nearly 3 years that Obama is ineligible for the presidency. But all you do is delete our emails and call us extreme. We will have the last laugh. And you will lose whatever minuscule credit you have left. The truth always prevails.
As I rambled, I saw a sign there, and on that sign said, no trespassing. On the other side, didn't say nothing. That sign is made